you hear me okay?
Yes.
Wow, it's working. I'm being filmed here too. So it's going to go on YouTube. So if you forget what I say today, just go to YouTube. You'll see it. Which is nice because they made me sign something saying I give you permission to go on YouTube. Because most places they do it, they don't even ask me. They just put me on YouTube. If you Google me, you'll see me on YouTube. All over the place. So, you know what my main job is, right? I'm in charge of the legal hotline. You know how many people we call the legal hotline last? How many calls we had last year? 86,000. How many of you call the legal hotline? How many call more than 5 times? We got some groupies who call like every week. Do I have any groupies in this room? No, you're not going to admit it anyway. But we're there for it. We got plenty of attorneys. Call as much as you want. We don't limit you. So you can even call on Saturday if you want. Saturday 10 to 2. The realtors that call on Saturday, it sounds like to me they've been drinking. I don't know. They're in a good mood on Saturday. I don't know. Better than a normal day. But you can be drunk and call. That's okay. We will take your call. Before we do the legal update, I want to tell you a couple of things about calling the hotline. A couple of new good things. One of them is sometimes, you know, you have a legal question, call the hotline. But some realtors, sometimes you're just filling out a form, right? And you don't understand how to fill out the form. So we want to give those realtors accelerated service. We want you to be able to get right through ahead of everyone, because after all, you pay for these forms. If you don't understand how to fill out the form, we want to help you, even if you're not in a transaction sometimes. So, if you're in zip forms, right, at the top of each page of zip forms, there's a little box that says Forms Help. If you click that box, and then you'll get a piece of paper that says, if you just have a question, you know, you get a screen that says, if you just have a question on how to fill out a form, then just type in your phone number and press the button, and you'll immediately get connected to the hotline. You'll go ahead and everybody else. But don't try to abuse the system, okay? We have some realtors who do that, and then we get them on the phone, and it turns out they really have a legal question, and they say, well, since I got you on the phone, can I ask you a legal question? And we say, no, call back. And we're going to put you at the end of the line. So don't try that one. The other new thing from the hotline, those guys zip forms, there's a new library on zip forms, just like a couple months, that says sample legal letters. You know, sometimes people, you got a problem with the other agent, right? And they won't present your offer, or you got a problem with the seller won't release a deposit, or the tenant won't leave, or the tenant won't allow you to show the property. There's situations that come up sometimes, and you want to really write them a letter to say, you know, the law says you have to blah, 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 you have to do this for me. And for years, people call the hotline and say, I got this problem, and say, what should I do? And we say, you should write them a letter. And then you say, will you write that letter for me? And you say, no. But now we have sample letters, sample legal letters that I mean, they're not copyrighted. You can just take them and modify them, put your own letterhead on it. But instead of having to call a lawyer, instead of making sure you wrote it the right way, we have the letters that are written the right way, okay? I mean, all sorts of situations. You ever hear of a situation where the tenant leaves the property, but they leave their stuff behind? Abandoned personal property, right? You know, you just can't keep that property. You have to write them a letter. You know, dear tenant, dear loser tenant, you left your stuff behind. You have 18 days to come and get it. Well, it has to be written a certain way. And we now have the letter exactly written the way you want to do it. Or another situation with a tenant. You ever had a tenant who just leaves without telling you they're leaving? They just disappear. You say, have they abandoned the property? Are they coming back? Do I have to do an eviction to make it official? And you know what? You don't. If a tenant abandons the property, they just leave. I mean, they owe you money, whether they owe you money or not, they just leave. And you want to re-rent it. But you're worried they're going to come back in 2 weeks. What'd you re-rent it for? I was just on vacation. Why'd you take all your furniture? Oh, I felt like taking, you know what I mean? So that's another letter. You can write them a letter and say, dear tenants, you have apparently abandoned the property. If we don't hear from you in 18 days, it's abandoned, we're going to re-rent it. That's another letter that has to be written a certain way. that's in the sample legal letter library. So I think you'll find it pretty helpful. So that's the latest.
Where was that again?
When or what?
Where was that? Where was those sample letters?
They became available, I think. They're there now. Oh, where? I'm sorry. Zip Forms. It's one of the libraries on Zip Forms. There's another new library on Zip Forms called DRE Forms. If any of you guys are brokers, sometimes you got to file a DRE form for record keeping or whatever. You can always go to the DRE website, but now we have the DRE forms that you normally use. You can also get them from Zip Forms. So you don't have to go to the DRE website and download it from there. It's right on Zip Forms. DRE forms, like for record keeping or for trust funds or things like that, if you ever need them, okay? All right. So, I want to tell you what's new. I want to tell you like some of the new laws, some of the new forms. As I said, this will be on YouTube. When will it be on YouTube? Tomorrow? Today? You can watch me over and over again if you want. On YouTube, just saying the same thing over and over again. And also, if you want this in writing, there's a, you can just call me at C.A.R, but on CAR.org, okay? That's your website. First page, one of your choices is legal. You go to legal. Then on the first page of legal, there's a list of things. There's two different things. One called risk management updates. And I do that every 3 months. And everything I say when I give these speeches is there. So I just uploaded one like a week ago or something. So if you look at the most recent February risk management update, it'll have this, what I'm saying today. Or, in addition, we have another tab right on the first page called 2013 New Laws, if you want all the new laws. I'm not going to talk about all of them. You know how many laws got passed last year in California? 870. You know how many of them had related to real estate? About 80. I'm not going to talk about 80 laws today, okay? I'm just talking about the highlights. But they're all there if you want to see them, okay? All right. So, let me start. First thing I want to talk about is taxes. People say, what's new with taxes? And the good news is not much. We were worried that they were going to change with this fiscal cliff thing, right? Yeah. We were worried that means, oh, they're going to mess around with real estate. They're going to limit, they're going to say you can't deduct mortgage interest. Didn't happen. Oh, you can't deduct property taxes. Didn't happen. You can still do it. Can't deduct PMI. Still can do it. No problem. Okay. And so that's all good. And they were worried about capital gains. Do you know if you sell a commercial property for more than you paid for, you got to pay capital gains. But if you sell your house for more than you paid for, you don't. How many of you guys have been in business at least 20 years? You guys, you remember like me that when you sold your house for more than you paid for it, you had to roll over the profit into the next house. So sellers didn't want to sell their house sometimes. They said, well, my house has gone up in value. I don't want to sell it. Because you had to worry about paying capital gains taxes. Now, if your house has gone up in value, you're happy. Yay, my house has gone up in value. I'm going to make a profit. And you don't get taxed on that profit unless you profit more than $500,000. I mean, if you bought it for $400,000 and you sell it for $1 million, okay, you've had a profit of $600,000. The first $500,000 is tax-free, but you will pay capital gains on that extra $100,000. But if you've profited more than $500,000, we don't feel sorry for you, do we? You should be happy you have all this profit. We don't care, you got to pay a little tax. So we were really worried they were going to limit that, but they didn't. And the best thing that happened, all of you guys are still doing short sales, right? I mean, people are still underwater. Okay. So let's say you owe the bank $400,000, but the house is only worth $350,000. So you say to the bank, will you approve a sale for $350,000? Even though we owe you $400,000. The bank says yes. We approve the short sale. So it closes out so the bank gets $350,000. You owe them $400,000, they only get $350,000. Can they sue you now for the extra $50,000? No. They can't. But since they can't sue you, the IRS says, well, they just gave you $50,000 of debt forgiveness. Therefore, you have to report that as income on your income tax as $50,000 worth of income. Fortunately, there's a law extended for 1 more year that says you don't have to pay that tax. So if any of your clients out there are thinking of selling, it's going to be a short sale, tell them you have to sell this year. Because if you wait until next year, you might have to pay income tax on the short sale. It might not get extended again. It was hard enough to get it extended this time. So under federal law, if you do a short sale on your primary residence, you do not have to pay income tax. But if you do a short sale on a rental property, you have to pay debt forgiveness income. So you know what you got to do if you want to do a short sale on an income property? Move in with the tenant. You don't even have to kick them out, just move in with them. As long as you're living there when you sell it, you're okay. You don't have to live there 2 of the last 5 years, you just have to be living there when it sells. And then you avoid this tax. It doesn't matter even if the house was refi. It doesn't matter if it's not, if refi is okay, you're still good. It's still good. All that matters is residential, primary, it's your primary residence.
I believe that if you have a second line, then, it is a refinance and you cannot get a tax forgiveness for that.
Well, it depends on what the money was used for. If it's used, if it's, it's a purchase money loan still, or you use that line of credit to buy the property, it depends. Talk to your accountant for the details. Better yet, don't give legal advice to your clients. Just give them the general advice. If you want to sell your house, this is the year to do it. Because next year, there's no guarantee you're going to get any tax break at all. So, be careful about that. So that's good. 1 more year, okay? So I was thinking pictures. It's not enough I'm on YouTube. I got to take pictures. All right. I'm not smiling now. Now,
The expiration date of that law?
it's 1 more year, December 31st. You got to close by December 31st. Now, who knows? Maybe it'll get extended again. You never know. Unfortunately, California has not yet complied with that. So today, as of today, if you do a short sale, you still may have to pay California income taxes. It looks like it's going to get passed, and it looks like it's going to get retroactive back to January 1st. So in my opinion, I think it's very likely that you won't have to pay California income tax either. I can't guarantee that at this moment, okay? All right, here's the only bad stuff for new taxes, for people who have a lot of money. And we don't care about these people anyway, no, I'm just kidding. But if your income is more than $450,000 married, 400 single, number 1, your income tax went up. Everyone else, the rest of us, same. And capital gains went up. Let's say you sell a commercial property, you sell income property, you sell a business at a profit. Okay, you got to pay capital gains tax. You know what the capital gains tax is? How much? 15%. But if you make more than $450,000, it's now 20%. Only for the amount over that amount. So let's say someone has an income of $100,000. 1 year they sell a big asset, right, for $500,000 profit. Their total income that year is $600,000. $600,000 is 150. They're married. That's $150,000 more than the $450,000. So $150,000 of that capital gain would get taxed at 20%, where everything up to that would still be taxed at 15%. Okay, so income or capital gain above a certain amount, if you make more than $450,000 married, 400 single, has gone up. And here's an important thing: anyone who makes more than $250,000 married or 200 single, there's a new 3.8% surcharge on passive income. You know what passive income is? Interest, dividends, rental income if you're not actively managing the property, or capital gains if you sell a property that's not part of your business. So 3.8% above their regular capital gains tax. So some people are going to pay capital gains tax of 23.8%. In other words, if you make more than $450,000 and you have a passive income, a passive capital gains, it's going to go up even higher. So you may have clients in this category, but it's not going to get better next year. So I mean, if they're going to sell, they're going to sell. It's not going to go better. It's only going to get worse. So for them, so that's the latest on tax. So So any questions on taxes before I go on? I'm not the tax accountant, don't ask me very specific questions, but I want you to know the basic things didn't change. Short sale, debt forgiveness exemption for 1 more year. Rates have gone up for certain high income taxpayers. Oh, one more thing. Estate taxes. You die. You want to give the estate to your heirs. Good news and bad news. The good news is the first $5 million of your estate is tax-free. The bad news is everything above that is now 40%. It was 35. Okay? Question?
Can you repeat that 23.8% on the passive income?
Well, 3.8. My point was, if you make so everyone over 250,000 has a 3.8% surcharge on interest, dividends, rental income on property that they don't manage, or capital gains on sales of property that was not actively used in a trade or business. Okay? And my point was, if you make more than, so that's 3.8 added to your normal capital gains. And my point is, if you make over 450, your normal capital gains is now 20, so 20 plus 3.8, 23.8. Whereas everybody else would be 15.8. If you make less than 250,000, like most of us, we don't care about any of this because nothing went up, okay? All right. Just get those rich people, you know what I'm saying? Okay, that's the latest on taxes. Ready? Next topic. Good news for you. And this is good news for the lenders especially. Up until now, I've been talking about short sales. But let's talk for a second about foreclosures. A lot of people are upside down, right? So people are getting foreclosed on. Let's use the same number I used before. You owe the bank $400,000, the house is worth $350,000. Not a short sale, it's a bank forecloses. They take your property. But it's only worth $350,000. But you owed them $400,000. After a foreclosure, can a bank sue you for the extra $50,000? Generally, no. If they do a normal trustee sale, auction foreclosure, no. But did you know in California, lenders have a second way to foreclose? It's called judicial foreclosure. They hire a lawyer. They don't do a notice of default. They hire a lawyer and file a lawsuit. But you know, if a lender does a judicial foreclosure, they can not just get the property, they can sue you for the entire amount you owe them. They don't just stuck with the property. They get the property and they can sue you for the difference. Unless it's a purchase money loan. So if it's a purchase money loan, in other words, the loan you use the money to buy the house in the first place, the lender, even if they do a judicial foreclosure, they can't go after the difference. But haven't we all refinanced our purchase money loans? Yeah. So now they're not purchase money anymore. Yeah. But here's the new law. The new law says even if you refinance, if it was originally a purchase money loan, doesn't matter how many times you refinance, it's still a purchase money loan. And the lenders can never do a judicial foreclosure and go after all your money. But there's one thing. It's not retroactive. So it doesn't apply to refinances that happened before January 1st. You know what that means? We all have to refinance one more time. Aren't the lenders happy about this? Yes. You need to refinance again. So me personally, for example, I refinanced last year. I don't plan on ever getting foreclosed on, but theoretically I could, whereas if I refinance one more time, I'm permanently invulnerable from a deficiency judgment after a foreclosure. Okay?
And if you bought the house all cash, you're still in trouble?
Well, theoretically. Yeah, theoretically.
What would you do to get out of that situation?
Question?
Not going to foreclosure.
What was the question?
Refinance.
Repeat the question, please.
He's talking about all cash. I don't know how you get foreclosed on. Loan on the property, but you know.
So they attach. You own something now that somebody bought you cash. You're the title owner now, but you owe it from the previous deal. They found out you short sale and foreclosed on that one, and now you own a house.
It's getting too complicated. Yes.
Can lenders pick and choose on the judicial foreclosure? In other words, is there a chance of discrimination if they?
Oh no, the question is, can they pick and choose who they're going to do a judicial foreclosure and who they're going to do a regular foreclosure? No, it's up to the lender.
And so
Don't worry about that. You may think to yourself, why doesn't every lender do a judicial foreclosure if it's a non-purchase money loan so they can go get an efficiency? And the answer is, it costs a lot of money. They got to hire a lawyer. They got to file a lawsuit. It takes a lot of time to get on the court calendar. And following a judicial foreclosure, once they do it, the person they just foreclosed on has 1 year to buy back the property. They can come up with the money. But of course, if you owe the bank like $3 million, and that property's only worth $1 million, and it's not residential property, they'll do a judicial foreclosure. They don't care how long it takes, because they want that extra $2 million, assuming you've got the money. If they think you don't have the money, they say they have the money. Okay, so that's good news there for, yeah.
But does that also include a line of credit?
A line of credit? Yeah, it's the same rules. And this only applies to 1 to 4 property we're talking about, right? 1 to 4, as far as these limitations on the, if it's not 1 to 4, lenders can always go after you for judicial foreclosure for the entire amount that you owe them. Okay? All right, next topic. Department of Real Estate. You've all heard of the Department of Real Estate, haven't you? As of July 1st, there's no longer going to be a Department of Real Estate. You can do whatever you want. No. They're just changing the name. Bureau of Real Estate. B-R-E. B-R-E. Bureau of Real Estate. But you all have business cards, don't you? They all say D-R-E number, don't they? Next time you order business cards, B-R-E. Now, the DRE, which is July 1st, they're going to be the BRE. They already, don't worry about it. I mean, if you got like 3 years worth of business cards, you're not going to get in trouble if you don't have BRE, but you're not going to look professional. Because you got old cards that say DRE, and all the new agents have BRE, and people are going to wonder, why are they so unprofessional? They don't have BRE. Why are they with that old DRE thing? So just start changing your websites and your business cards, because July 1st, Bureau of Real Estate. Are there any new laws from the BRE, or soon to be the BRE? A couple of things. I don't know if any of you are thinking about getting a broker's license. To get a broker's license, you've got to do 4 things. You got to pass the broker's test. You got to pay the fee. You got to take 8 designated college-level courses. And then the 4th requirement is either full-time, you're a full-time agent for 2 years first, or you have a 4-year college degree. New law says if you want to use the 4-year college degree way, you have to actually major or minor in real estate. That makes sense, doesn't it? I mean, if you don't major in real estate, what's the point? What's so good about a 4-year college degree? You know? Oh yes, I majored in basket weaving. You know? Why should you get a broker's license? Okay. One more thing is kind of interesting. I know none of you are ever going to get sued, of course, but it used to be, okay, a lot of times when realtors get sued and they settle with the plaintiff, as part of the settlement agreement they say, the plaintiff agrees not to file a complaint with the DRE. That's part of the deal. Oh, you want us to give you some money? Then you have to promise in writing, swear to, you'll never file a complaint against me with the DRE. Can't do that anymore. New law says you just can't. That would be illegal part of a settlement. It'll be that thing. Okay? All right. So that's enough on taxes. That's enough on deficiency judgment. That's enough on DRE, soon to be BRE. Next topic. Disclosure. There's a new disclosure law, but you don't have to worry about it because it's going to be automatically in the purchase contract. There's in Northern California, a couple years ago, San Bruno, California, which is south of San Francisco, there was a horrible thing that happened. There was a underground gas line that blew up. And it's horrible because the people were living above it, they got killed. Just like that poor guy who went to the sinkhole. Imagine sitting in your house and it blows up. It's not a terrorist, your house just blew up. You know, so it's a horrible thing. So obviously the question is, do realtors now have to know where the underground lines are, so you have to disclose to the buyer where they are? And the answer is no. But the law does say you have to tell the buyer how they can access this information. So it's just going to be right on the purchase contract. There's only going to be one change to the purchase contract this year. There's going to be one sentence that says, buyers are advised that the Department of Transportation has a website, and it'll say the website, that tells you the general location of underground pipelines that have natural gas or any dangerous substances. Not all underground lines, not like electrical lines or anything like that, but underground gas lines. So it's just like Megan's Law, right? You don't have to investigate to see where the registered sex offenders live. You just have to tell the buyer that there's a website that they can look at, which is paragraph 6D on the purchase contract. So now there's going to be a paragraph 6E on the purchase contract, right? That says where the website is for the underground gas lines. Okay, so you don't have to do anything. It's just going to be there. Yeah.
What the disclosure or hazardous disclosure report covers that?
Whether your natural hazard disclosure company says that they cover that or not, it doesn't really matter. You're still going to be using the C.A.R. contract. You still got to do it. But I know you're going to use the C.A.R. contract anyway, so that's all you got to worry about.
But what
I'm sorry?
What about new construction contracts?
What about it?
Do they have that?
Oh, yeah, it's in it. Yeah, it's got to be in all purchase contracts. All purchase contracts. All right? So that's the only new disclosure law. That's the only new thing regarding the purchase contract. Okay, what else? Let's talk about rental property. A lot of you are probably landlords, or you work for landlords, or you're property managers. There's all sorts of new stuff. Or stuff that was going to expire that got extended. First question is, if you have a tenant and you want to get rid of the tenant, I don't mean kill the tenant. I mean, you want to evict the tenant. How do you do it? Well, you got to give them written notice, right? The question is, how many days notice do you have to give them? Normally, it's 60 days, right? Do you know there's 2 times that you only have to give 30? Number 1, the tenant has been there less than a year, month to month. They can only get 30. Second, did you know that if you're selling the property where the tenant is living, even if they've been there more than a year, as long as the buyers write on the purchase contract that they intend to occupy the property for at least 1 year, you just have to write that in on your offer, additional terms or something. Buyers will occupy for at least 1 year. If you write that, then the tenant only is entitled to a 30-day notice. Every other tenant gets a 60-day notice, but there's one tenant who gets a 90-day notice. And that's a tenant who was on the property when the property was foreclosed on. So in other words, if you're an investor and you buy a property at auction, you buy it, and there's a tenant already there, you got to give them 90 days. And it doesn't matter if you're going to live there or not. It doesn't matter how long you're going to live there. It doesn't matter how long they lived there. They could have moved in 2 weeks ago. You got to give them 90 days notice. That law was going to expire December 31st. It got extended for 7 more years. So for 7 more years, foreclosure tenants get extra time to leave. Now what if you have a tenant who's on a lease, right? They're on a lease, and the lease is over at the end of a year. How much notice do you have to give a tenant to leave at the end of a lease? 0. You call them up the night before. Just a friendly reminder, your lease is over tomorrow. And then the tenant says, oh yeah, when do you want me to leave? Tomorrow. Now, there's no form you have to give them, but one of the new letters I told you about on the sample letter library is the letter to write as a courtesy to a tenant at the end of a lease. Just a friendly reminder. I didn't have to tell you this. You're supposed to keep track of this yourself. But friendly reminder, you got to be out of here. Now, what if you buy a property that's a foreclosed property, you got a tenant on a lease? Well, normally if you buy a property from a tenant on a lease, you got to wait till the end of the lease to get rid of it, right? What if you buy a property at a foreclosure sale, and there's a tenant there who's on a 3-year lease? Are you stuck with that tenant for 3 years? No. 90 days. The same 90 days. So in other words, when you acquire a property where there were tenants there, if the tenants were there on the day of the foreclosure, whether they were on a lease or month to month, they get 90 days. And you're right. Usually these REO agents do cash for keys. They just get them out earlier. You can always get a tenant out early by bribing them. Tenants, it's legal to bribe.
What if they haven't been paying rent?
Yes, I'm assuming, everything I just said, I'm assuming the tenant is paying rent. If the tenant stops paying rent, I don't care if they're on a lease or whatever, for a 3-day notice to pay or quit. So tenants have to pay rent. Some tenants are like, oh, my landlord's in a short sale foreclosure. I know they've stopped paying their mortgage. Well, if they stop paying their mortgage, I don't have to pay them rent. Wrong. Wrong, wrong, wrong. You still got to pay rent.
So just back to the question, if they have a 1-year lease, you're saying they don't really need notice, they have
Exactly.
it the next day.
Right.
So, but that reverts to a month-to-month, they send them.
If you accept, at the end of a lease, if you accept the next month's rent check,
Okay, so that would.
turn it into a month-to-month, so now they get 60.
Okay.
So whatever, at the end of the lease, don't accept any more rent.
How about the trustee sales and short sales? Is it also apply these rules?
Yeah, remember the short sale is just like any other sale. But a trustee sale, if you acquire it and they're on their foreclosure, there are special rules, 90 days.
Okay.
Section 8 tenants get an extra 90 days. Now we're talking like 6 months. And then you're in LA rent control. Section 8 tenant in LA on a foreclosure. Give up. Just kill yourself. You're never getting the tenant out. The tenant's going to be there as long as they want, right? Assuming they pay the rent.
So if a property is transferred to a new owner, does the existing tenant or the new owner have to make another agreement with the
No.
existing tenant?
If you acquire a property that's already got a tenant, you inherit it. So if they're month to month, they're still the same terms month to month. If it's a lease, you inherit the lease.
So you didn't have to.
But I'm glad you asked that, because here's another new law. It says if you buy, I'm sorry, go ahead.
Because the form that they use is the old form, and I would like to use a C.A.R. form.
Uh-huh.
So anyway, and also they didn't have all the other disclosures. So can
Was this a month-to-month tenant?
Correct.
If you inherit a month-to-month tenant, you can change anything.
Anything.
Because they're just month-to-month. You can give them 30-day notice to change everything. To evict them, you'd have to give them 60. But if you want to increase the rent, change the terms, just say, here's your 30-day notice to change the terms.
But they've been there for a long time though.
Doesn't matter.
So 30 days.
Yeah, 30 days to change things.
So you can start the disclosure like move in, move out, and all the other
Everything,
stuff.
yeah.
Okay.
But I'm glad you asked that.
Thank you.
Here's another new law. It says if you acquire a property,
Yeah.
right, that's got a tenant on it, you, the new owner, you have 15 days to tell the tenant that you're a new owner, this is your address, this is how they can pay their rent, this is the form of rent, this is my address for service of process, and here's a copy of the rental agreement. If you don't do that in 15 days, the new tenant doesn't have to pay you rent until you do it. So when you acquire a rental property, you make sure you get this documentation to the new tenant, or else you're not going to be able to evict them if they don't pay their rent until you start doing this.
Could you explain about if a previous owner collects the rent,
Yeah.
even it's already foreclosed,
Right.
and the deposit, security deposit?
Interesting question. Previous owner collected security deposit,
And
then you foreclose on them, and they don't have that security deposit. You inherit the tenant, but you don't inherit the security deposit, right?
Yeah.
You got to come up with the security deposit. The tenant says, I don't care that the other owner took it, you're my landlord now, you are responsible to have my security deposit. So when you acquire a property that has a tenant on it, whether you're buying it or foreclosing on it, you try to figure out, make sure you get the security too, because otherwise it's up to you to come up with that money, okay?
One more question. Can I increase the rent then?
30-day notice.
30 days.
Unless you're going to increase it more than 10%, 60-day
No,
notice.
there's no rent control. So
It is or is not rent
It's
control?
not the rent control.
Double their rent. Triple their rent.
LA,
Yeah,
Section 8 plus rent control.
right.
So if you acquire property foreclosure, can we just, the new owner can just relocate them, to pay the relocation fees?
You know, I'm not gonna answer that. I always have to have the rent control ordinance in front of me before I answer questions like that. Call the hotline, we can go over it, but it's complicated, that LA rent control thing. And I don't memorize that stuff. I don't memorize LA rent control, okay? Because I gotta deal with San Francisco rent control, Berkeley rent control, Santa Monica rent control, Oakland rent control, they're all different. East Palo Alto rent control, they're all crazy, so I don't memorize them. If you call the hotline, we can definitely access it for you. Okay,
Question.
yeah.
Regarding the question that did the new owners, give them like the lease, okay, but they want to change, increase the rent, you said like the 10% is a 60-day notice.
If it's on a lease, you said lease though. Lease, you can't change anything till the end of the lease. If they're month
end of
to
the
month.
lease, month to month,
Yeah.
and then if
Yeah.
she doesn't pay, she doesn't agree the term, and then the
Then you
new
can
owner
evict
can
them.
evict them.
Right, right. Okay, yeah.
Do you have any new law that applies to commercial and office buildings?
I haven't got there yet. So far, what I'm saying, that's all you care about, right? You only came for the commercial? There are a couple of commercial things I'll talk about in a little while. Yeah.
What is the percentage of late fee that is negotiated?
Very good question. How much of a late fee can you charge a tenant? The answer is whatever reasonable. What do courts think is reasonable? Anybody know?
No.
Our guideline that we know is considered reasonable is like 5%. Now, some judges will say 10% is okay. But every judge in the world will say 5% is okay. But there's no law. There's no standard. There's no law. I can say, oh, the law says this. There's no law. All you can do is charge a reasonable fee. So we try to figure out, as lawyers, what do judges think are reasonable. And I'll guarantee you, every judge will say 5% is reasonable.
Don't you have to have it in contract?
Yeah, even if they agree to, it doesn't matter if they agree. Court will say that was unreasonable. They shouldn't have. You forced that poor tenant to pay that. No. Even if you put it in the rental agreement, it's not enforceable unless it's reasonable.
And the security deposit.
Security deposit, there are rules. There are specific rules. It can't be more than two times the rent if it's unfurnished, 3 months if it's furnished. So there are rules for security deposit. There are no rules for late fees other than what's reasonable. And also, you can't charge the late fee until they're at least 5 days late. Why? Because judges think that's reasonable too. Judges don't think it's reasonable to charge a 1 day. If they're 1 day late, if there's 1 day late, you can give a 3-day notice to pay or quit, but you can't charge a late fee. Crazy. Okay. By the way, one more thing I forgot to say: when you give a foreclosure tenant a 90-day notice, there's a special form you have to use. For a 30-day notice, you can just write your own form. I mean, there are forms available, of course, and you should use it, but you can just take a piece of paper and say, I'm giving you a 30-day notice. That would be legal. I'm giving you 60-day notice. That would be legal. But for a 90-day notice, there's a special form you have to use. It's on zip forms. It's NTAF, Notice of Termination After Foreclosure. You can't just use any old form for a 90-day notice. Yeah?
If you charged a 10% or even 15% late fee, what's the penalty if you get caught?
There's no penalty. The judge just may not allow you to collect it.
Right, so you only lose a month.
Yeah. He's saying, what the heck, I'm charging whatever I want. What's the worst that can happen? Charge him 50%. There you go.
One last question.
He said the last one was your last one. I'm confused. Okay.
On the security deposit,
Yes.
okay, I usually see they have there's a 1 month rent or twice.
Right.
They charge for non-refundable cleaning. They charge for keys.
Can't do it.
Is that legal?
Cannot do it.
Okay.
First of all, cleaning, if you clean it perfectly, they can't charge you a non-refundable cleaning deposit. They can't. Or keys, what? I mean, they can security deposit, but if you return the keys, they got to give you back the money.
Or they lost it.
Yeah.
Like elevators.
I mean, the keys, they can charge you for if you lose the key. I mean, that's reasonable. But cleaning costs, no. Okay. All right. Yeah.
What about some condominiums charge move-in and it is in escrow? So
They charge tenants or they charge buyers?
The buyer's $250, but then the buyer does not move in and the tenant is going to move in. So,
Are you asking, can the homeowners association charge the fee? Is that your question?
yeah.
That's a
They
good
charge
question.
250, but then.
If you're ever dealing with an HOA and they have a fee that you think is dumb, like a $250 move-in fee, whether I move in or not, something like that's what you're saying.
Right, it's already in.
You can always challenge HOA fees. HOA fees have to be fair and reasonable. Of course, how do you challenge them? You got to sue them. Do you really want to sue the HOA for $250? If you got time on your hands, go ahead. The HOAs get away with everything because no one wants to sue them. And you can't report them to the police or something. I want to call the HOA police. I'm sorry, we have a problem here. No, HOAs aren't regulated. I mean, there's a new law. Remember last year there's a new law that says if you're buying a condo, the HOA can charge you charge the seller a transfer fee or a documentation fee to prepare the CC&Rs and mail them, but they can only charge the actual cost. So some HOA says, oh, we're going to charge you $500. You say, no way it costs you $500 to Xerox the CC&Rs and mail it to the buyer. It probably costs you like 20 bucks. They say, if you don't pay the $500, we're not going to do it. So what do? You do it. You pay it. And then if you want to, at close of escrow, you can file a small claims court action against the HOA and make them prove that they actually spent $500 to do it. And you'll probably win if you got all the time to do that. You know.
That also happens on refis. They charge an exorbitant price.
You're talking about HOAs.
Right.
The HOAs can only charge fees that are actually reasonable. Okay. Another thing, yeah.
Can you tell us something more about the overcrowd for income property? Like property, 2-bedroom and 1 bath, and about 8 people wanted to rent on that.
Yeah.
And how to manage it?
Okay, let's say, let me make it a general question. How do you avoid getting sued if you're a landlord and you want to reject somebody? For example, his question is, can I reject someone because there are too many people? I got a 2-bedroom and 80 people want to live here. You could say no. You can say that's too many. What's the guideline? 2 per bedroom plus 1. So if you have a 2-bedroom apartment you're renting, and 5 people show up and say, we want to rent here, you can't say there are too many of you. Come up with another reason.
Credit's not.
But don't use the reason there are too many. Whereas if 6 people show up, they say, well, my guideline is 2 per bedroom plus 1. This is a 2-bedroom, that means 5. You are 6, that's too many. Okay? But my general question is, I'm glad you asked that because landlords get sued all the time by tenants who they reject. Oh, I know why they rejected me, because I was my race, my religion, my skin color, I had too many kids. That's why my credit, they say something like that. The only reason you can reject a tenant is for objective reasons. Their credit, their income, their criminal record, their foreclosures in their record, bankruptcies in their record, unlawful detainers in their record, something like that, too many people. But here's what landlords like to do. They say, they collect all the applications and they get like 5 that they really look good, right? 5 applications have good credit, good income, good everything. Oh, good, I'm just going to pick the one I like best. Well, then the other 4 are going to sue you. Because they're going to say, I had credit just as good as the one they took. My income was just as good as the one they took. Why did they take them over me? It must be my race. It must be my religion. It must be how many kids I have. It must be the color of my skin. And how are you going to defend yourself? Oh, I just like them better. Yeah, right. You just like them better. It's because of their religion. You know how you avoid getting sued? You take the first tenant who meets your criteria. You can have very high criteria. I need an income of $1 million a year. I need a credit score of 850. You must have been on your current job at least 20 years. Whatever criteria you want, that's fine. It can be very strict. You don't have to be, you can be very, very strict. Write that down on a piece of paper. But then the first applicant who meets that criteria, don't wait till you collect all your applicants and then start doing, you just one by one, the first one that meets your criteria, you meet my criteria, you're hired. you're here. Because then nobody can sue you. You didn't reject anyone who met your criteria. You're not allowed to just pick the one you like best. Because then the ones you don't like best have a potential lawsuit against you. Because they're going to say, oh, you like them best. Why'd you like them best? You know what I'm saying?
How about altering your?
The HOAs are starting to limit the amount of people that you can have in your.
They've got the same rules. They can't be more restrictive either. You're saying an HOA will not allow people to buy there, or they won't allow the owners to rent?
To rent there.
Well, they
To have more than 2+1. They sent out a notice saying that we cannot rent to more than 2.
HOAs can pass rules restricting the owner's ability to rent. Of course, those rules have to be legal and reasonable also. And if in your case it was 2 per bedroom plus 1, they would be able to get it. In other words, you're saying the owner of the condo might be willing to rent to more than 2 plus 1, but the association of the condo says no. Yeah, the association can probably get away with that. Okay? It's interesting. I mean, landlords can say, it goes both ways. I mean, a homeowner, do you know a homeowner association has to allow pets? Landlords don't, but HOA has to allow at least 1 dog or cat. But if you own the condo, right, and you rent out the condo, you could say to your tenant, no dogs. And the tenant says, if the other people living here have dogs, so, well, they're not tenants. You're my tenant. I'm your landlord. It doesn't matter what the association allows. I don't allow it.
You said you could keep your qualifications high.
You could if you want, yeah.
I mean, okay. What if you make a qualification, for example, $100,000 income?
Right.
But then somebody comes along that you like, and you just say, well, I'm going to lower it for you.
Well, if you've already rejected someone based on income, and this person you do rent to actually has just, doesn't have any income any higher than the one you rejected.
But you can change. I mean, as time goes on, you may decide, well, maybe I'm too high, so I want to lower.
So maybe you should call back the other one that you rejected and say, hey, now you're meeting my criteria. You know what I'm saying? The reason I'm saying is these people are trying to set you up. They're not real tenants. They are setting you up. They're trying to catch you. That's why I mean.
Are we obligated to show them the what kind of applicant you got?
What do you mean?
I mean, like you said,
that's what I was gonna
this year
ask.
compared this applicant and the other applicant.
Have you challenged your
No, you're not obligated to tell one applicant about your other applicant. What I'm saying is if you get sued, they're going to subpoena. And they're going to subpoena, the judge is going to order you to produce all the applications that you rejected and didn't reject. No, you don't, unless you conveniently, accidentally shredded them when, without looking. I don't know how they made it into my shredder, they just didn't. I forgot I'm on YouTube. I gotta say. That was just a joke. YouTube watchers, I was kidding about that.
Landlord has the right to reject any more applicants, right?
You can, yeah. You guys understand what I'm saying. This is not rocket science. You understand the basic concept of what I'm saying. So let me know more. Well, okay, I'll take a couple more questions. Yeah.
When tenants move out,
Yeah.
and they hand a lot of things, big pictures and the
Yeah.
walls, they patch it up, but
Right.
it's different color all over the house. Can you deduct?
Can you charge a tenant who took down their pictures, patched up the holes, but you don't like the way they patched it?
It's terrible.
Yeah.
Every room is wiped out. Can we charge for?
You can charge them, and they take you to court, and then you can take pictures, show the judge the pictures. Some judges are going to be sympathetic to you. Some judges are going to be sympathetic to the poor tenant. It's up to you. I mean, you never know how the judge is going to react,
After I collect the application fee to run the credit,
Yeah.
if tenant wanted a copy of the credit and all the information they gave to me after I reject,
Yeah.
do I have to?
Yeah. By the way, one more thing. What if you do reject a tenant? You're not being rejected. Do you have to tell the tenant why you rejected them?
Yes. No.
Technically, no, unless you rejected them based on their credit score. If that's your criteria and that's the reason this tenant was rejected, there's a form you have to give them saying, I reject you based on your credit. If you reject them based on their income or based on how many there are or based on they haven't been on their job long enough or something like that, you don't have to tell them. But you know what? If they ask me, I tell them. Because if you don't give them a reason, they're going to get suspicious. Oh, it's probably not a good reason. Why won't they tell me why they rejected me? You just say you didn't meet my criteria, which are very objective. I have credit, and you don't meet it. My criteria is you got to be on your current job 10 years. You've only been there 8 years. I'm sorry. That's my criteria. You can do that.
Reflect to the tenant, like let's say the tenant, 2 bedrooms, 5 people stay there, but
Right.
3 months later end up at 8 or 9.
Well, then get rid of them.
How do we, as a
Evict
landlord,
them.
how do we then start to serving them?
You evict them.
3 notice?
3-day notice to cure, which is basically 3-day notice to get those extra people out of there.
And if they refuse it?
You evict them.
Okay.
Unlawful detainer. Throw them out. You know, this can turn into a landlord-tenant class. So. I got to tell you just the new stuff, okay? One more new thing is, relatively new is, related to this issue is, landlords, do you have to allow pets? No. But what if the tenant says, I got a pet, you said I don't allow pets. The tenant says, I'll pay extra for the pet. That's okay. You can allow pets just to people. In other words, you can discriminate sort of against pet. You can say no pets, period. On the other hand, you could also say your rent is this if you don't have a pet, but your rent is this if you do have a pet. But if the tenant has a service pet, not only do you have to allow it, you can't charge extra either.
They have to be a registered.
They don't. That's the problem. Some people, I mean, obviously, visually impaired person, seeing eye dog. Hearing impaired person, service dog. But what if the doctor just writes a prescription? I believe for my patient's emotional well-being, they need to have this pit bull living with them. You know what? You have to allow it. And you can't charge extra. And you can require them to be leashed. You can require them to be, have the proper shots and everything, but there's no registration it's kind of crazy. This probably needs to be changed because people are really starting to abuse this.
How would you legally get out of it?
You can't. That's the whole problem.
Can it be posted on your requirements?
No. If a doctor says they need this for medical reasons, unless it's an inherently dangerous pet, like a cobra, or a grizzly bear, you can say no. But pit bulls are not, I threw pit bulls out there because they're not considered inherently dangerous.
Yeah, they are by insurance companies.
I'm glad she just read my mind. Some insurance companies will not give you insurance if you allow certain pets. So imagine you're a landlord, right? And here's your choice. Reject tenant with pit bull and get sued by tenants. Allow tenant with pit bull and lose my insurance. That doesn't seem like a fair choice, does it? You know what we're waiting for? The test case.
There you go.
Which one of you wants to volunteer to be the landlord that rejects? Actually, what we're trying to get is the Department of Fair Housing to issue a rule. Because that's a very good question right now that's just come up a lot. The insurance won't, I mean, you can't be required to allow pets that cause you to lose your insurance. I mean, you can't have a rental business without insurance on the property. That seems ridiculous. On the other hand, other courts have said, oh, you got to allow the pet. We need a rule from the Department of Fair Housing, or we need a case.
Can you give a weight limit?
If it's reasonable.
You can carry the dog.
Now, are you talking about a service pet or any other?
No, I had one.
Are you talking about a service pet?
No, just a regular.
Well, then you don't have to allow it at all. So we can have any weight limit you want.
No, if HOA says if you have the pet, it has to be so.
Oh, the HOA would have to have a reasonable rule. In other words, and HOAs, remember what I said, they have to allow pets. But they can have reasonable restrictions on the pet. Landlords don't have to allow pets unless it's service or assisted animal.
An owner in a condominium.
Oh, then they're just like any other landlord. But you got to follow the HOA rules if they're reasonable.
I can hear that. The doctor said he's something, and it sounds like the doctor, any doctor is qualified to say something looks like, sounds to me, it's above the law. From my understanding.
In other words, does it have to be a psychiatrist, right?
Right.
My foot doctor says I need a pit bull for my emotional well-being. You could probably challenge that.
Doctors get three opinions. So one doctor says.
Are you asking me a question or are you just complaining?
How can we just according to one doctor saying and say that's it? That's my question.
I'm not saying it's fair. I'm just saying that's what you got to do. That's what you got to do. I thought I said we're not turning this into a landlord.
How about K-9?
K-9. Oh, that's a good question. That's a good question.
What was the question?
You have no. I'll repeat it. You have a no pet policy, right? Then you got a prospective tenant who's a policeman with a K-9. He says, I want to live here, and you have to allow me to live here with my dog. And the answer is you don't. You can say no police. You can't say no police. But you can say no police with dogs. Okay? Seriously, you're allowed to do it.
Does a tenant have to disclose when they bring in a pet, whether it is a service pet or just a pet? I mean,
I'm assuming on the application they're going to indicate whether or not they have pets. If they say they don't have a pet, they come on the pet, they're in violation of the lease. Right?
Well, there's a good case up north that someone actually set the landlord up because they brought in a service dog later on and then he did not disclose it up front.
I'm assuming any landlord should get it in writing up front whether or not the tenant has a pet and whether or not pets are allowed. Two more questions.
I want to retract the fees, okay? Now, the question that becomes personal. I want to get some answer from you. Number one, you said there's no cleaning fees, right? Now, if the property, we allow the pet, I was actually, I was advised by the agents in Pennsylvania that they can collect cleaning fee to deflate the property when the tenants move out.
Yeah.
Because the next tenant could be allergic to it.
I said if you have a pet, you can charge extra.
Yeah.
Extra
But
deposit.
you didn't specify.
Yeah.
And the other one is you said no keys, possibly.
I'm not sure what you're asking about the keys. I mean, they're trying to say to the tenant, here's, you got to pay security deposit and an extra key deposit?
No, it's non-refundable fees, I'm sorry. It's like keys in garage, remote control. A lot of these tenants.
They're just saying, so it's not, you can't have a non-refundable deposit.
Okay.
You can just charge a fee though. I mean, your first month's rent is $20 more than every other month.
Right.
You know why? Because I'm going to use that for key deposit, something like that.
No, it's.
But they can't have a non-refundable deposit.
It's not non-refundable deposit. It's going to spell as non-refundable fees and specify what these fees are for.
Okay, it's part of the rent then. Just charge more rent.
Okay,
Yeah.
so you prefer that way better?
Yeah.
All right.
In the past, because they're so litigious, we were allowed to discriminate against lawyers as tenants.
You know, he's right. And I would never rent to a lawyer. But that law was changed. You cannot discriminate on someone's profession. Assuming it's a legal profession. I mean, if they have the oldest profession, yes. You know what the oldest profession is? I'm not going to tell you if you don't know. A couple more things you need to know, and then we're not going to talk about rentals anymore. As of January 1st, carbon monoxide detectors are required in multi-unit residential. Prior to this year, just single-family rentals. I know a lot of lenders and appraisers have already required them, but up until this year, if you had a fourplex you were renting out, you didn't have to put a carbon monoxide detector in every unit. Now you do. Apartment buildings, everything from duplex on up, every unit has to have a carbon monoxide detector, unless your building, and there are buildings like this, are electric only, no fireplaces, and no attached garage. So a property that has no, no fossil fuel burning heater or appliance, no fireplace, and no attached garage are exempt from the carbon monoxide detector requirement. But it now does apply to multi-unit, okay? Yeah. Yes?
What if it is all electric, but you do have an attached garage? What does it make?
Well, people could have cars in there that produce carbon monoxide detector. Don't question the law, just do it. Yeah.
Give all of the owners a copy of the master policy and just notify them the carrier.
If you want a copy of it, you're entitled to it.
They have to give it to you?
Yeah, if you want it.
Is there a law that just like the Vegetarian Act?
Yeah, I don't know where it is. It's in there though. Call the hotline. If I had it in front of me, I'd find it. You're welcome. All right, a couple more things with rentals before I go on from rentals. Can landlords prohibit smoking? Can they also say, not only can you not smoke inside the unit, you can't even smoke outside? Yes. Can a homeowner association say no smoking in the common area? Can the homeowner association say you can't smoke inside your unit?
Yes.
Can the homeowner association say you can't smoke on your balcony because the smoke goes into the neighbors? Depends on the CC&Rs if they define the balcony as your property. It's still your property. You can smoke and blow the air into your neighbor that you don't like, right? That's okay. All right. What if you have a prescription, though, for medical marijuana? So the landlord says no smoking. You say, excuse me, I have a prescription. I'm going to smoke my marijuana all I want. No, they can say no. It violates federal law. They say, what if I just bake brownies? No, it's still an illegal substance under federal law. All right. One more thing, good news. On the, I mentioned when at the beginning when I was talking about that sample library, I said, if a tenant leaves behind property, right? They abandon personal property. You can't just take it, you got to write them a letter. Dear loser tenant, you left your stuff behind, right? And that's one of our letters on our sample library. Okay. So what if you have to give it at least 18 days. You can give them more, you can't give them less. So you're writing them a letter, 18 days. 18 days, you haven't heard from them. Well, you don't know where they live, you mail it to that address. And if they don't take care of it being forwarded, it's their problem. Okay, so you mail the letter, first class mail. Wait patiently 18 days, no tenant. They still left their couch behind or whatever, or their table, dining room stuff, whatever. Now what do you do? Well, is it yours now? No. Now you have to ask yourself, what is the value, the resale value? What could I get on eBay for this stuff? You know what I mean? What's the resale value of the abandoned personal property? Now, if it's below a certain amount, you can just throw it away, keep it, do whatever you want. But if it's above a certain amount, you ready for this? You have to actually sell it at a public auction, which is known as a garage sale. But or if you don't want to have a garage sale, you have to continue to store it forever. Here's the good news: that number, that threshold, has finally been increased from $300 to $700. So I'm sure it's not worth $700. Just keep it, right? Unless they leave like fancy computer equipment that's worth like $10,000. You got to track down that tenant or sell it. Well, if I sell it, can I keep the proceeds? No. You can pay yourself a generous sales commission, probably at least 50%, and a generous storage fee, of course. But if there's any money left, you have to give it to the LA County Clerk's Office. I bet no one has ever done this once in history, but anyway, that's what you're supposed to do, okay? The big news is it changed from $300 to $700, okay? Finally, all the years I've been in real estate, it was $300. It's finally more than that. Commercial, it's even higher. Commercial, it's $1,000, I think. Speaking of commercial, at least one person wants to know. The rest of you don't care, but there are 2 new laws on commercial property that you need to know. Number 1. Let's say any of you own a commercial property. I mean, if you guys are realtors, you may own your real estate office, right? That's a commercial property. Do you know certain commercial properties have to have access to disabled persons? Now, you think, don't all properties have to provide access? No, not all. Depends on how big it is. I mean, let's say you have your office is on the 2nd floor of a, mini mall or something like that, and there's no elevator. and someone shows up in, wheelchair, and how do I get up there? You must put in an elevator. Do you have to put in an elevator? Well, probably not, because based on the size of your business, it would be so cost prohibitive. The Americans with Disabilities Act is going to say, no, you're exempt. Okay, well, how do you know if you're exempt or not? How do you know what the rules are? How do you know if your business or your client's business is in compliance with the Americans with Disabilities Act or not? How do you know? There are experts. You ready for this? They're called Certified Access Specialists. So here's the new law. You ready for this? Effective July 1st, if any of you or your clients are renting out a commercial property, you're representing them as the agent to lease the commercial property, you have to disclose to the new tenant if the property has been inspected by a certified access specialist. You notice I didn't say you have to get a certified access specialist to do it. I'm just saying you have to tell the tenant whether you have or not. And if you have to tell them whether the property is in compliance or not. I suspect if you tell the tenant that you haven't, they're probably going to say, I want you to get that checked out before I lease your property. I mean, I'm thinking all landlords should have already done this anyway. Because if you have a property right now that is not in compliance with the ADA, you can get sued right now by a disabled person.
Right.
So I think all commercial property owners should have already done this. But the new law says, as of July 1st, it's got to be in the lease, actually, with the new commercial tenant, whether or not the property has been inspected and whether it's in compliance. Okay? Yeah.
But the city sometimes have that ordinance already.
Cities also have ordinances sometimes in addition to the Americans with Disabilities Act, and obviously you got to comply with whatever the city ordinance says. You got to do it. Okay. Second thing, if any of you work with big commercial properties, let's say you sell big buildings, commercial buildings, or warehouse or something like this. Effective July 1st, if you sell or lease a commercial property with at least 50,000 square feet, 50,000. But starting next January, it applies to commercial properties over 10,000 square feet. Starting July 2014, it applies to commercial properties over 5,000 square feet. What is it that applies? The new law says if you sell or lease the entire property for a commercial property that's that big, you have to disclose to the new buyer or the tenant how much power you've been using, how much electricity, what your utilities have been. But then you also have to tell the new tenant or the buyer how that compares with the normal power usage of a property like this. So in other words, you got a 50,000 square foot building, you got to say to the buyer, this is how much we've been paying for utilities, and this is how much a normal 50,000 square foot warehouse does. How do you get that information, you're asking, right?
Yeah.
You can do it, it's for free, it's a little cumbersome, but you got to go to the Environmental Protection Agency's website, epa.gov. You search for something called Energy Star, then search for something called Portfolio Manager, and there's software you can actually get this information. It's possible to do, it's a pain, but you can do it, it doesn't cost you anything. Okay? That's the latest on commercial. Let's talk about a couple of other things. Let's talk about things you really care about. Money, commissions. See, I knew it. Good news and bad news. The good news is, there was this, some brokers like to charge their clients fees. I'm charging a 5% commission, 6% commission, plus I'm also charging you a transaction fee, an escrow coordinator fee, a transaction coordinator fee, a short sale negotiator fee, my niece's college fund fee, whatever. I'm charging a fee. So, is it legal to charge a fee to a client in addition to a commission? Always I used to say yes, no problem. Then there was a case a couple years ago where a broker charged all of his clients $150, $149 administrative fee. And then all of his former clients got together and sued him. Class action for a refund of the $149. And their argument was, you can't charge a commission plus a fee unless you can prove that you provided extra service for the fee that was exactly equal to $149 worth of value. Of course, the poor broker couldn't do this. So the court said, you got to pay everybody back their $149 times 3. He was liable for like $10 million. Here's the good news. Went all the way to the U.S. Supreme Court. U.S. Supreme Court said, no, that's wrong. There's nothing in the law that says you can't charge a fee or that you have to justify the fee. As long as the client is willing to pay it, you can charge it. Go ahead and gouge your clients. Just charge them whatever you want. Make up fees if you want to. Of course, your client could quit. Your client could say, wait a second, on this listing here, it says I got to pay a commission plus a $200 fee. What do I get for that fee? I'm sure your potential client could argue with you, and you have to prove to them why it's good. But the point is, the U.S. Supreme Court basically said, the government doesn't have the right to question your fees. You can charge anything you want. Seriously. So that's good. Second question, though, is what about, instead of you charging your client a fee, you hire like a third party who charges you, and you want to pass the fee on to your client? You know what I'm saying? For example, short sale negotiators. If you've got your own short sale negotiator, you can charge the client whatever you want. But if you hire an outside short sale negotiator who doesn't work under your license, they work for someone, they're independent, they hire them for the deal, and they charge you like $300, you can only charge your client $300. You know what I mean? You can't mark it up. You understand what I'm saying? Okay. So you can't mark up third-party fees, but you can charge regular fees. That's good. We get a lot of questions on referral fees. Nothing new here, but remember, you can always compensate your own client. Some of you don't like this, some of you like this, but it's okay to say to a buyer, you work with me, I'll give you some of the money back. It's okay to take a listing and say, you list with me, close of escrow, I'll give you some money back. I'll give you a TV set, I'll give you a refrigerator. I mean, it's okay to give incentives to your own clients.
That's not considered as kickback.
It's a kickback, which sounds like a bad word, but it's a legal kickback. It's a legal rebate. What you're not allowed to do is pay people to refer you business. Hey, if you know anyone who wants to buy a house, you refer them to me at close of escrow, I'll pay you. You can't do that. That's an illegal referral fee unless the person you're paying has a license. Now, this only applies on sales or loans on residential 1 to 4. If you're looking for a tenant, you can say, if you find me a tenant, if you refer me a tenant, I'll pay you. That's legal. Doesn't apply to rentals. It also doesn't apply to more than 4 units. So if you're trying to sell a 6-unit building, you're trying to sell a piece of land, you're trying to sell commercial property, you can say to someone, if you refer me someone, I'll pay you. But you can't solicit referrals on sales of residential 1 to 4 unless they have a license. Obviously, you can pay referral fees to people with licenses. And by the way, it doesn't have to be a California license. They got a Texas real estate license, you can pay them a referral fee.
Can you give a gift after close of that?
Can you give them a thank you gift after close for the referral?
Yes.
As long as you do it like on their birthday or something where it makes it look like it's actually a birthday present. I mean, technically giving them a gift is just like giving them money. But let me be very specific to his question. All of you have former clients, unless you're brand new, and hopefully you were so good that your former clients are going to refer you business. Not because you offered them money, because they think you're good. I mean, that's the whole idea of building up a clientele is you do good work, your clients give you business. After a few years, you don't have to cold call anymore, you just get referrals. Can I give those people thank you gifts? Yes, of course, because you didn't solicit their referral. They just gave you the referral because they like you. You want to thank them? Thank them. Give them whatever you want. Give them a car if you want. It's a thank you. What's bad is when you solicit referrals. You put ads out in the paper. I pay referrals. You send me referrals, I pay you. That's like putting in the paper, come and arrest me. I am a criminal. Because you're actually offering referral fees, which you're not allowed to do. You can't solicit referrals. But as I said, if former clients or current clients give you business, you didn't solicit it. There was no arrangement where they understood if they gave you referrals, you were going to give them something. They just gave you a referral. You want to thank them? That's fine. Of course, a guy asked me yesterday, a guy, I was down in Redondo Beach, and he said, a former client of mine came to me and said, hey, I got a referral for you. Will you pay me? So even though it was a former client, he specifically was saying, I'm giving you this in exchange for money. And the answer I'd tell the guy is, no, you can't pay him. Whereas if he had just given you the referral without asking for anything, you could have given it to him. So you can only pay the ones who don't ask for it. The ones that ask for it don't pay them. But that's, if you understand how the law works, the law specifically says you can't pay referrals pursuant to an arrangement. In other words, you agree that you do this and I'll do this. Whereas just a referral because they like you, there was no pre-arrangement there, give them something. Okay? It gets complicated, yeah.
Did you say 1 to 4 units only, or it applies on everything?
What I'm referring to only applies to sales or loans on 1 to 4. If it's something else, federal law or RESPA, the law I'm talking about, does not cover it. There's no law. Now, different than referral fees to that you receive from title companies, escrow companies, lenders, don't do that. Not just residential 1 to 4. You know what I'm saying? I mean, it's illegal for realtors, lenders, escrow, title, termite, home inspectors to give each other referrals. And that's not just 1 to 4, right?
Do you have a maximum amount to pay them?
That's a very good question. People always ask me, is there a maximum amount? If it's legal, there's no maximum. It's either totally illegal or illegal. Now, your accountant may tell you there's limitations on what you can deduct on your taxes. That's a different issue. But if it's that, talk to your accountant. But if it's legal to do it, there's no limit on how much. It's either completely illegal or it's completely legal.
Is there a section in the hotline that explains all this in terms of the...
We do have a Q&A on referral fees and...
But do you give the basis for it like you're just doing...
Yeah. We have a really good Q&A on referral fees and rebates and stuff like that.
I have a question on commission. Of course, your agency's trying to get businesses. They said,
Right.
to other buyers, I'll give 1% back, right?
Right.
Okay, it's very common in
Right.
advertising. And the seller knows, right? The
Right.
seller will say, Vivian, you know what? If they don't want the commission, since I'm giving commission to them, well, if they don't want the 1%, I'm just paying them, 1% less. Can the seller do something like that?
Question is, of course, there are agents out there soliciting business saying, you work with me, I'll give you 1% back. Okay? And the seller sees those ads. And the seller says, well, tell you what, if you sell it to someone, to an agent who doesn't offer that, give me the 1%. And you can say to your seller, drop dead, seller. You signed a listing already. Of course, they're going to say, well, then I'm not going to work with you again. But whatever. I mean, I feel bad for you guys having to deal with this stuff, but I mean, that's what you got to do. Yeah, you signed the listing. They have to pay you, right? There's no ability to do this. All the things we're hearing about now, of course, are agents not presenting offers. Remember, and we have 2 letters in our sample letter library. One is demand to present my offer. The other one is demand to allow me to participate when you present your offer. Do you know that as a buyer's agent, not only do they have to present your offer, they have to allow you to be there when they present it. And the only way they can't do that is if the seller signs something in writing that says, I specifically do not want the buyer's agent to be present when their offer is presented. There's all this fun stuff going on now. I mean, you see listings, right? They hit the MLS on Friday. They say you can show it on Monday, and then Sunday it's pending.
Yes.
Let it become pending before you can show it.
What happened?
They double-ended it. How is that good for the seller? I mean, the seller wants to sell it for as much money as they can,
question.
The way you sell property for the most money you can, you expose it as widely as possible. There are rules about this now. You know, you can actually, there are some circumstances where the buyer's agent can actually call the seller and say, you realize you sold your property for less than my buyer wanted to pay? You're going to start doing things like this because or you file complaints at the MLS against the agents who do this, because you have the right to have your offer presented and be there when it's presented.
Can you tell this information to your buyer? Can your buyer go meet the seller?
Your buyer can contact the seller.
You can do so, right?
Knock on the door and say, did you know you sold it for less than I wanted to buy it? I mean, agents should, and they have these private MLSs, these clubs. You have any around here? Where all these agents get together and they share, they don't put them in the MLS, they just share them with themselves. This little group. I'm wondering, how is that in the seller's interest? To limit the exposure of their property.
I have a question. That's the agent, he never called me on my listing, he never show up. Later he bring me an offer.
Yeah. So?
He never show up, he never show the property, he bring me, when he send a buyer, bring me an offer.
He doesn't have to look at it before he wants to buy it.
Yeah, he wants to buy it.
He just wants to buy it. It's so good, he wants to, your advertising was so good, you didn't have to see it.
Pictures were good. The agent show the property and let him to write.
Okay, didn't say that. She's saying she had a listing and one agent showed up with a buyer.
No, never show up. The agent never show up and he write me an offer.
But you say another agent showed it?
He could have just walked in.
I'm not understanding your problem. All you're telling me is you got an offer from an agent who didn't show the property.
I'm the listing agent.
Right.
And then one agent called me, he never called me about the my listing.
He just called you.
He just say, I had an offer to you, and then I wait a minute. You never call me on my listing, you never show your buyer.
So what? It doesn't matter.
It's illegal?
Yeah. You don't have to. In this market, crazy things happen. Crazy things happen in this market.
Eight, you
Yeah.
have, on the bottom of, after the escrow,
Yeah.
how do you make the agent to send you back the rejected page 8?
They don't have to. I mean, the question was, on the purchase contract, the last page, there's a place for the seller to say, I rejected your offer. That would solve a lot of problems, you know? I mean, a lot of agents get so mad if they don't think their offer is presented or whatever. I tell listing agents, just get your seller to initial that they rejected, send it back so they're happy. It shuts them up, you know, they understand. Of course, then agents are going to forge their seller's signatures. And we don't want that happening. That would be a criminal act, but yes, but you can't force them to do it. You can't force a seller to reject an offer. You know what I'm saying? Ideally, they would be nice enough to do that, but sellers don't have to respond at all to the offer. The listing agent has to present it. Now, I go to some places, like I was up in Palo Alto, where they get like 40 offers per listing. And they do not want to. They're not going to present 40 offers. So what do? They put back in the MLS, they say, okay, everyone present your highest and best offer next Tuesday. They're basically saying resubmit and make it better. You know what I mean? So there's nothing wrong with that if the seller knows what they're doing. I mean, agents aren't supposed to hide things from the seller, but if the seller agrees with the agent, I don't want to look at 40 offers. That's the way the seller wants to do it. You know what I'm saying? That's okay. But, you know, it's just agents. Obviously, the problem is when agents do things that are in their best interest but not their client's best interest, like double ending it, even though they could have sold it for more money to another buyer, but they got greedy and wanted to double end it. That's wrong on so many levels. That's ethically wrong. That's a violation of the rules. You can get sued for that. The DRE can take away your license for that. All these bad things can happen, so don't do it. And report people who do it. You know, I mean, you have to do these things. What else was I going to say about? Oh, bad news. Unfortunately, it's my job to tell you good news and bad news. I know it's mostly bad news, but let's say you had a listing for $1 million, and you got a full price $1 million offer, cash. Does the seller have to accept that offer? No. So what's the point of making a full price offer? Well, at least you earned a commission, right? Not anymore. You ready for this? There was a court case where a broker had a $17 million listing. He got a cash offer, $17 million. The seller countered it at 21. I got you a full price cash offer. Oh, I guess it was too low then. And they countered it at 21 million and the buyer went away. Well, the buyer's agent got mad. And the seller's agent got mad. We worked hard to get this thing sold. We want our money. The commission was 6%. That's like $500,000 to each agent. Do you understand why they sued? Yes. But they lost. The court said, oh no, they don't have to pay a commission because they didn't sell it. And then we said, Your Honor, did you read what the listing says? The listing says you've earned a commission if it's an acceptable offer or if it's an offer that meets the terms of the listing. This offer clearly met the terms of the listing. Judge said, oh, that's not good enough. It's not good enough that it means it also has to sell. In other words, he didn't read the listing what it said. But that's what the court said. And the broker tried to appeal it to the Supreme Court. The Supreme Court wouldn't take the case. So that's the law now in California. A full price offer does not earn you a commission. RealPro. If you Google the word RealPro, R-E-A-L-P-R-O, or you just take my word for it. You guys all doubting me now. But the point is, we're going to have to change our listing form. So in April, when you see the C.A.R. listing forms, they're going to say to earn your commission, you got to sell the house. Now, I bet most of you already thought this. Let me ask a question. Have anyone in this room ever sued a seller for not accepting a full price offer? You got a couple. Did you win? You wouldn't win again. So, unfortunately. It's not a common thing, but you at least like to have that leverage. At least you know you could do it if you had to. And I bet if you had a $17 million listing, you'd think about it. You'd start doing the math. Saying, yeah, it's worth it. You know what I'm saying? So, but I hate to tell you it's bad news, but that's the way it is. Yeah.
I submitted an offer on February 23rd, and I haven't, and then 2 days later, the guy put pending. He hasn't even responded to my wait for it. He has not accepted. He has not.
Has he responded to you?
No, he hasn't even.
First of all, if they don't respond to your offer within 24 hours, some MLSs say 48 hours, it's either 24 or 48, you have the right to contact the seller directly. Do that. Now, if he had responded to you and said, "Oh, yeah, I'll present," and then it went pending, then you file a complaint for not allowing you to participate, for him not presenting it. So the first thing a listing agent has to do is to acknowledge that they got your offer. And if they don't do that, you can contact the seller directly. If it's an REO, forget everything I just said. They're going to do what they want. You have no hope. You have no hope. A normal seller, though, is supposed to follow the rules. So they have to present this. They got to first acknowledge your offer, or else you can contact the seller directly. Assuming they do acknowledge your offer, their next obligation is to present it. And not only present it, allow you to be there. And the only way that they don't have to do that is, number one, the seller doesn't want it presented, or number two, the seller doesn't want you there when it's presented. And you're entitled to that in writing. Otherwise, file a complaint.
On the last page of your listing form, they all, have your name and your license number and the date.
Yes.
The day of the listing or the day of your license date?
No, it's not the day of the license. It's just the day you're signing it. Yeah. And it doesn't really matter, right? There's no legal significance to that anyway. Don't worry about that. By the way, a couple more things. I'll take your question, but a couple more things I want to tell you. Do you know, as a broker, you can do your own escrows? In other words, you don't have to. You can actually have your own. You can only do your own deals, right? You can't do escrows for other deals, but you don't need to get an escrow license to escrow your own transaction. There's a new law, though, that says at the end of the year, which will be starting at the end of 2013, if you do your own escrows and you do at least 5 in a year, or you do at least $1 million worth in a year, you have to file an annual report with the DRE, which next year will be the BRE, telling them how many you did, how much money, and what your account number was for your trust account, stuff like that. So originally it was going to take effect this year, but it's moved back a year. that any of you guys that are brokerages that do your own escrows, keep track of them now. Because you're going to have to file an annual report by March 1st of next year. Okay? All right. Yeah, there are a couple questions.
It's something about risk. Should we?
Some of you start talking before I pick you, you know, you're violating all the rules here. Or this guy,
back to your earlier scenario where you brought in a full price offer and you didn't pay a commission.
Right.
I heard that there was something about a time frame now that you had to file for that prior to the listing expiring.
No.
There's nothing that's changed in that.
Nothing's changed there. No. Yeah. Nothing.
Last time you told us about like the deposit on the offer.
Yeah.
Like always listing say, you know, like the deposit released to the seller. The initial deposit.
Yeah.
You know. No.
What about it?
Last time, one of the clients mentioned about if let's say I'm the listing agent.
Right.
And then there's an offer coming in 3% deposit.
Right.
And then the listing agent say, okay, this after open escrow, 15 days, release to the seller and non-refundable. Cannot do that.
Can't do it.
Right.
Right.
Still cannot.
Still can't do that.
Uh-huh.
The only thing you can do is you can do something like this. Let's say the buyer is getting ready to close. The buyer says, I need an extension. Seller, could you please give me a 2-week extension to close escrow? Then you could say, okay, yeah, I'll give you an extension, but here's the price of the extension. You will release the deposit today, non-refundable. Yes. And a court would say that's okay, because that's fair consideration for the extension. But you cannot, as you said, you cannot put in the original offer, after 20 days, after 30 days, seller will release a deposit, buyer will release deposit non-refundable. Of course, just won't enforce that.
So right now, there's a current escrow. The escrow officer released the money to the seller already.
Why?
Because they follow the instruction from the offer.
So it's set in the contract. Well, it's not the escrow's fault. They follow the instructions.
Yeah, so we
the
tell
buyer
the
should
listing
soon
agent,
get the money back.
you cannot do that. And he said, no, we have to do that.
Like I said, if the deal falls apart,
it is loan didn't approve.
then the buyer can sue to get the money back.
Could it say something like, these days it's very common for loans not to be guaranteed after the 17-day contingency.
Right.
Could it say if the loan contingency is not released or any of the contingencies not released on time?
Can't do that. Another thing you cannot do is to say, buyer and seller agree that if buyer doesn't remove their contingencies on time, the money automatically gets forfeited. No. You cannot do that.
But you can ask for it after that 17 days if they want that contingency not to be signed.
Perhaps. In other words, that's a very good question. I know for a fact that there have been cases that say, in exchange for me allowing you to extend the closing, you can have the deposit released. I think you're asking, what if you know it's extending the time period to remove contingencies? Maybe. Maybe you can be in a test case. You'll be famous one day, right?
If after you receive the monies and the deal falls apart after the extension, does you keep that money as a seller? You still have to keep it.
You still keep it. The question was, you agree to release the deposit in exchange for giving an extension, but then the buyer still doesn't close. Too bad. You paid me for the extension. Not my fault you didn't close. I guess you needed even more time, you know?
Can I ask increase deposit?
What about it? Increase deposit in exchange for an extension or something like that?
From very beginning, like
our contract says, there's a clause right there that says you can have an initial deposit and an increased deposit. That's perfectly legal. First paragraph, paragraph 2. You can do that. Don't look at me like that.
Normally, deposit is about 3%.
Right, but you can have more than that. You can have increased deposit.
If I requested the buyer to increase $100,000.
Yeah, if they agreed to it, that's okay. As long as it's not non-refundable. You know what I'm saying? I mean, they got to give it back if the deal doesn't go forward. I'm going to leave it a couple minutes, but I'll get you credit to make sure there are a couple of things I covered. Remember, we got this homeowner's bill of rights now. What that means is, if you apply for like a short sale or loan modification, if you have to ask for it, but if you ask for it, the lender will give you a single point of contact. they have to tell you, okay, this guy here, or this woman here, she is your contact. If you ever have a question about what's going on with your situation, you call her, she's got to know it and respond. Not only that, sometimes you're negotiating a loan modification and the lender's also started a foreclosure against you. This single point of contact has to keep track of what's going on both sides. Not only that, once you start the loan modification, they have to stop the foreclosure. They can't be doing a foreclosure while they're negotiating a loan modification. What about a short sale? If you're negotiating a short sale, then they start a foreclosure. Can they do that? Yes. But once you get the short sale approved, they have to stop the foreclosure. The point is, you have a single point of contact, though, who knows everything that's going on at the bank regarding your file, and they have the power to do these things. So if this doesn't happen, call C.A.R. so we'll make sure that...
Is that a person or a department?
Unfortunately, it could be a person or group of persons. Like 100 people. I hope it's not 100 people, but unfortunately it's not just a single person, okay? But that's the latest with that. You're getting multiple offers, right?
Yeah.
Let me ask you a question. You get an offer, you list it for $300,000. You get an offer at $310,000. You counter it at $320,000. And while you're waiting for the counter to come back, you get a new offer at $340,000. So you tell the seller, you know, we countered at $320,000. We're waiting for a response. And now we got a new one at $340,000. What do you want to do? The seller says, I want the $340,000. Can they accept the $340,000 even though they got a counter out? Yes.
Oh, don't you have to wait for...
Don't argue with me. No. Don't have to wait. But that's a good question. I'll tell you why. Because here's what will happen, though. Okay, so you sent out the counter for $320,000, right? What do they have to do to accept your counter? They got to sign it and send it back. And we do everything by email now, right? So they're going to email it back. Well, when is it official? When they send it? No, when you open the email.
Right.
Receive it. In other words, receiving the email. So, that's a serious comment. Okay, so let's get back to my scenario. You counter for $320,000. You're waiting for an answer. You get a new email offer to you at $340,000. You immediately tell your seller, says, let's grab that one. So that means you got to sign it and send it back to the second agent. So you sign it and send it back, and then 2 minutes later, the first counteroffer comes back signed. So the question is, did you get that? Did you open that email before the second agent opened your acceptance of the second offer? And you know, there's going to be an argument. People can argue about when they got the email, when they opened the email. You know how you solve that problem? You don't do that. In other words, the counter that you sent out, before you accept the new one, cancel that one. Email the first agent and say, you know that counter I just sent you? Ignore it. Rescind it. You can rescind it by an email. We have a form to do it. It's a nice form, WOO, withdrawal of offer. But a simple email that says, the counter offer my seller sent you dated March 3rd is hereby revoked. And send a return receipt requested. Of course, they're going to be hiding from you. They don't want that email, right? And then you're hiding from them because you don't want their email, you know? Everyone's turning off their phones and computers and hiding from each other. Hey, if you can't find the other agent, you can't deliver the email.
I text you before after I emailed you. I text you, I send you an email. Are you obligated to open it?
Nope.
Okay,
nope.
Good.
In fact, if you text me, you send me an email, you tell me that's an email I don't want to open. I'm going to turn off my computer. Turn off my computer right there. It's better you send me the email without telling me to read it. The point is, we do things electronically now. In the old days, some of you guys and me, we remember the old days. We remember you delivered these things by messenger, or you delivered them by hand, and you made them sign for it in front of you with witnesses. By the way, you can still do it that way, you know. You don't have to. We don't have to be lazy butts and send everything by email. But when you send things by email, you're always setting yourself up for the other person saying, I never got that email. Prove I got that email. prove I got that counteroffer. I don't know what you're talking about. And in a multiple offer situation, this happens. The offers are going back and forth, counteroffers are going back and forth. Or imagine this, you get 3 offers. You want to counter all 3 of them. Can you do that?
Yes.
Sure. So if you counter all 3, and they all come back. Who bought the house? The first one back. Then they're going to argue who was first. The way to avoid that one is easy. You check on each counteroffer form, paragraph 4, multiple counteroffers. Then you're telling each buyer, you're not the only counteroffer. So you can sign it and send it back, even if you're the first one back, you don't necessarily bought it. Because since I checked the multiple counteroffer, I'm telling you the seller has to re-sign and then send it back to you to make it official. Here's something that agents do that's wrong. They get one offer, they get another one that's coming, but it's not there yet. But they're impatient. So they want to counter the first one without waiting for the second. But they want to keep their options open, so they check the multiple counteroffer box on that one counteroffer. That is called fraud. You're lying to the agent by telling them this is a multiple, but it's the only one you sent. You can't make it. And then agents sometimes, they send out one counteroffer, not multiple. They get a new offer, they want to counter that one, so they call up the first agent. I'm turning the first one into a multiple. You can't do that. You've got to rescind it and reissue it.
Can I call your bluff and say you have to show me the first page redacted that I know you legitimately have another offer?
You can't. You can ask me that, I can ignore you.
Yeah.
On the other hand, if it turns out that you really doubt that I was doing what I said I was, you can file a lawsuit against me. You can subpoena that. You want to go that far.
Okay.
I always put in that the seller reserves the right to choose the buyer of his choice.
In other words, you're sort of making your own version of paragraph 4 of the multiple counteroffer.
Right.
And you can modify the counteroffer and say that. If you sent me that, my reaction would be that you're not really telling me anything. It's not even a counteroffer.
Yeah.
But that's what a multiple counteroffer is. It's nothing. It's really just telling me, go ahead and sign and send it back, but I still may not go with it.
Right.
But in this market, you probably get away with that. Buyers are so desperate to buy. So yes, you can write on your counteroffer. She's just creating her own multiple counteroffer language, basically. And you're saying, I can do this even if it's not a multiple. If buyers are going to go with that, because buyers are kind of desperate right now, they may go with that.
I do that on buyer's side too.
Yeah.
In regards to the fraudulent multiple
Yeah.
counteroffer situation, are you aware of the DRE catching anybody doing that during an audit?
That's a very good question. The answer is no, but I'm aware of lawsuits.
Because I suspect that goes on all the time.
I think it does.
Yeah.
In fact, I gave this speech about a couple months ago in Long Beach, and this realtor came up to me after the class. I've been doing that for 20 years. And I said, stop doing it. Because there have been lawsuits where the agents... So no, I've never seen the DRE look for that in an audit.
Seems like it would be very easy to catch.
Yeah.
Yes.
They may start. By the way, the DRE has started to do these mini audits.
Yeah.
You brokers in the room, they just show up.
I think I'll make a mention of that at the DRE forum.
Yeah. They call them mini audits. They call them mini audits. And they're typically, you know what they do? They walk in and they say, here's what they usually say. They say, oh, by the way, is your broker here? And then they say, how often is he here? They're looking for absentee brokers. So is there a manager here? And they say, where does the broker live? In San Francisco, really? And your office is here in LA? Interesting. They're looking for absentee brokers who are not managing the business. So all of you brokers, obviously you have a system in your office where if you're not there, there's someone on call who regularly reviews files. That's what they're looking for when they do these mini audits, okay? Do you have to let them in? If it's the DRE and you don't let them in, you're asking for trouble. You're now a target. What is he hiding? I guess we're going to get a full-blown audit tomorrow. You're right. So, yes, you don't have to let them in. But I would not advise that. Unless you really do have a lot of stuff to hide, in which case, come on in, hide everything. And just kidding on YouTube, just kidding.
You've seen this happen, everybody's seen this happen before. Shouldn't there be a system in place to prevent this like basically me having to call you bluff that you tell me you have multiple offers, you have none, and all you're getting me to do is to ante up. Should not a system be in place to protect
You mean
the
there should be
seller?
something on the form or something that
Something
says...
in our documentation that
That if you're giving, you have to provide, in order
You send me
to
the
provide a
first
multiple
page.
counteroffer, you'd have to submit with that
Right.
proof. I don't know.
Otherwise, this game playing has been going on for years.
Yeah, you're right.
No, seriously.
You're right. Maybe there should be an ethical rule, you have to do that. I
Yeah, but
doubt
ethical
we can get a law passed.
Ethical won't hold up. We
I'm not
agree
sure we
to
get a law
practice
passed to
ethics,
that.
but a lot of us don't.
Yeah,
Some
I'm
of
not
us-
sure we get a law passed to that.
Confirmation is not signed. It's accepted.
Right.
Agent tells you, it's accepted.
Right.
March 1, but you don't receive anything signed until March 5th.
Right.
Says, well, your contingencies is 12 days later. No, I just got the contract.
Yeah, very good question. In other words, you submit an offer, and seller accepts it, and they actually call you up and tell you they've accepted it. Obviously, they're supposed to send it back to you. Or maybe we're going the other way around. Buyer signs, seller signs, sends it back. Is that what you're saying? So the seller didn't even send it
agent
back.
called you back and said, hey, it's done.
Okay.
I just got to get, mom is out in
Right,
San Francisco, and when that's signed, I'll send it back to you.
Right.
4 or 5
It's
days
not a
go
deal
by.
until it comes back. It's not even a deal. So in other words, if they say they signed it, and then finally 5 days later they send it back, the deal didn't become a deal until they send it back, so all the deadlines start on that day. Not
Also, too, at that point, it expired then.
exactly. I mean, the offer died after 3 days.
Yes.
So you write the offer today, right? They call you up tomorrow and say, we accepted your offer. You say, send it over. Because we have nothing until you send it over. Then finally, 3 days from now, they send it over. Well, guess what? It died in 3 days. After 3 days, then you could say, you were too late, I don't care. That offer died at 5 o'clock yesterday. I don't care. I mean, I bought something else in the meantime. On the other hand, if you're okay with that, if they send it back late and you're okay with that, by the act of opening escrow, you sort of bring it back to life. It's like a miracle. It's alive, but yeah.
Does the acceptance, I mean, you know how when they have agent confirmation, is that a must, or is that just?
So the next question is, okay, buyer signs it, goes to the seller accepts it. Next thing, to make it official, the listing agent has to send it back to the buyer's agent. Now, his question is, well, then the buyer's agent's supposed to sign that confirmation of acceptance, that they received it back.
Right.
That's not mandatory. What makes it official is that you delivered it. As soon as they receive it, you have a deal. But, of course, how do you prove you delivered it if they don't sign that?
Show me signing the RDA.
But you could theoretically send them an email, return receipt request that includes the acceptance, and if you can prove that they opened the email, they can't deny they got it even though they never signed that confirmation. Wouldn't it be nice if just everyone was honest and ethical? And half of what I'm saying today would be unnecessary because, of course, you would do the right thing and sign the confirmation and send it back. Of course, you present the offer. Of course, you'd allow the agent to be there when it's presented. Because after all, who knows the offer better than the agent who wrote it? Why shouldn't the seller hear from the agent who wrote it? Isn't that in everyone's best interest? If everyone just kept that in mind, we wouldn't have any problems. And I suspect the people that come to a class like this, you're the good guys. I bet you can all think of people who you wish were here. Of course, they would ignore it anyway, right? I mean,
exactly.
I mean, that's the problem, but we do the best we can. Yeah.
As far as notification goes, would it be wise to incorporate the RDN into the purchase agreement?
Listen to what he said. It's a very good point. Up until now, I've been saying to make it official, you have to send it and be able to prove that they got it. We have a form that he just mentioned called the RDN, Receipt and Delivery of Notices. And what that form says, if the buyer and seller agreed to it at the beginning of the deal, they're saying, we agree that in order to deliver something, all I have to do is prove that I sent it. And it works both ways. So let's say I'm a buyer and you're a seller. I'm a buyer's agent, you're a seller's agent. I know you, I trust you, you know me, you trust me. And we just get together and say, let's sign this RDN form. Let's agree right now that in this deal we're doing together, I'm not going to worry about if you got my email. You're not going to worry about if I got your email. We're going to agree between us that I'm going to give you one email address, you're going to give me one email address. and we both agree that if I need to send you something, all I have to do is prove that I pressed send, and you got it. On the other hand, if you want to prove that I got something, all you have to do is prove that you pressed send. And then we have to play the game of, did you get it? Are you sure you got it? Did I send it to the right email? It would solve a lot of problems if both, I mean, I like that form. I like that addendum. In my opinion, I think that makes sense. I mean, emails usually do go through, you know, I mean, it's rare that they don't, so why not put the burden on the person to read their emails? You don't have to worry about sending a return receipt request and can I prove that they opened it? It's easy to prove you sent it, right? As long as both sides agree that that's, so I think that's a good point, I think that's a good addendum to use. I'm leaving in 1 minute, so this better be good.
Can listing agent require buyer to do inspection like within 24 hours of acceptance and open the escrow with after written acceptance?
So your question is, can a listing agent require the buyer to do their inspections within 24 hours of opening escrow?
No, opening acceptance in writing and open the escrow only after they say, okay, this is fine, we are not going to complain about condition.
Are you saying you want, can the listing agent say that the buyers will do their inspections before they open escrow?
Yeah.
That's possible. They do that in Northern California now. They're getting so many offers on their listings, they'll say things like, they'll put things up at the open house and say, if you want to buy this house, we're not even going to look at your offer unless you've removed your contingencies before you write the offer.
Agreed.
That's even worse than yours. That's even, yours says they got to do it before they open escrow. This says before you even, we're not even going to look at your offer if it has any contingencies. That's legal. Including appraisal. Oh my God, that's standard practice. Standard practice now is they remove the appraisal contingency before they write the offer. Sellers won't even look at them if they have appraisal contingency. This is because we are in a seller's market. We are in a low inventory seller's market. Sellers have the power. Buyers have no power right now. So you want to make your offer stand out by removing contingencies and having short time periods to remove contingencies. 2 more questions and I'm gone. No, you're too late. I meant these 2 that already have their hand up. She didn't ask a question yet, so I'm going to make it 3, yes. And him and him. Him and her.
I'm representing the buyer, and I called the listing agent to show the house on the market. It's a process. The first call was, oh, the house is not available showing, and she checked my name and phone number when it's available.
Right.
1 week later, second call I called them. They said, oh, it's still not available. The third call that I called, they said, oh.
It's sold.
Yeah. They accept offer already, and also like a lot of backup offers. And the status on there.
File a complaint. The question is, you know, she kept calling to see if the property she could show it is not available, then all of a sudden it's sold.
How do we file?
You file a complaint with the MLS. And first I'll write a letter saying, when can I present my offer? And when they don't do that, you file a complaint.
To where?
At the MLS. Multiple listings. It's a violation of the rules. Yes. No, I was skipping you because your hand wasn't up at the time. No, it wasn't. It was her.
She's recently happened, so get confused. Friday get acceptance and escrow close, okay? Within 3 days, we need to deliver the check. How about the Monday delivery still too late? During the Saturday, Sunday, they get a higher offer. Can they kick buyers out?
The deal was accepted, right?
Yes.
And then the buyer has 3 days to open escrow, right? But they made it within 3 days.
Come from
3 business
Friday
days.
or
It's business days.
Saturday?
3 business days.
Yeah.
Yeah.
No, it's not business days.
You have 3 business days to open escrow after the offer is accepted. Who's arguing with me over here? It's 3 business days. Wrong. She's rarely wrong. But
No, it's business.
You probably know there for a legal
yeah.
One of the things he reminded us, of course I'm not old enough to know this because I've been in the business, was that in the times when things were really crazy in real estate, and agents advise their buyers to release contingencies, which are shorter than the diligence period that they have to receive disclosures from the seller, would put you at risk even 2-3 years down the road of a buyer being disgruntled saying you didn't do your job.
Well, yeah, obviously. I mean, obviously you have to advise your clients. I mean, the point is this. You're going to advise your clients, you want to make your offer look good. You might want to reduce the amount of time of removing contingencies. On the other hand, you also have to protect your client by saying, of course, we probably want to make sure at least we get the disclosures before we remove our contingencies. It's all, yeah, you have a fiduciary duty to your clients to protect them. So, yeah, you could be setting yourself up if you...
Right. So unless you put in writing, maybe, is there something you can say to the, your client, hey, I don't advise you doing this, but this is what the market is.
We have a form. We have a form to give to buyers on the risk of removing contingencies, or I forget what the form name is. Call the hotline number we can give to you. So we're thinking like you are. We have a form to do that. I said I was done, didn't I? I'm done. Thank you.